At my son's $85,000 wedding, Monica's father tapped my calloused hand with his champagne glass and said, "Frank proves every elegant family still needs a good plumber." Everyone laughed. Jason laughed too. 3 days later, a lender placed my son's forged signature in front of me. The wedding had been held at Hudson Glass House, an independent event hall overlooking the river in northern New Jersey. I did not own it. My company had replaced its boilers 5 years earlier. That was the full extent of my connection to the building. I paid the same contracts any father would have paid: venue, catering, rentals, flowers, music, and photography. The total was capped in writing at $85,000. That money was a one-time gift from my personal savings. I promised it to Jason before I met Monica or her parents. I had spent 40 years turning a union plumbing card into Kowalski Mechanical, a company with 32 employees. I could read a pressure gauge by sound. I could find a bad invoice before the ink dried, but I had never learned where support ended and rescue began. Jason's mother died when he was 17. I responded by working longer hours and paying for every consequence I had missed while I was gone: a wrecked car, an abandoned college semester, 2 business ideas that lasted less than a winter. By the time he asked for a wedding, money had become the only apology I knew how to make quickly. Monica's parents described themselves as an old New York family. They said their money was trapped in the refinance of a Manhattan property, so they could not contribute until after the wedding. I did not ask them to repay me. The gift was mine. They still selected the imported flowers, designer table linen, and 12-piece band at the reception. Monica's father wore a white dinner jacket and told 3 strangers that Jason had escaped the trades. Then he gave the toast about every elegant family needing a plumber. My brother Ray stopped smiling. Jason stared at me for half a second. I waited for him to say that the plumber was his father. He lifted his glass instead. Behind him stood a memory table with a photograph of his mother. In that picture, she wore the small gold wristwatch her father had given her on our 10th anniversary. The real watch rested in a cedar box at my house. I planned to give it to Jason on his first wedding anniversary. I looked at her photograph and kept my promise through the end of the night. Every vendor was paid. No server, musician, driver, or florist lost money because the groom was ashamed of his father's hands. 3 days later, a commercial lender called my office. "Mr. Kowalski, we need to verify the accelerated draw on your equipment line." "I have no equipment line with you." The lender sent a representative that afternoon. He brought a $275,000 application for a new excavator and trenching system. The package included a personal guarantee bearing my signature and a corporate resolution authorizing Jason to request the funds. Jason was my purchasing coordinator. He could order fittings within an approved budget. He could not borrow money, pledge company assets, or sign my name. "Has anything funded?" I asked. "No." The request to accelerate the draw triggered a second review, then place a fraud hold on it and preserve every file. That protected the money. It did not tell me whether Jason had forged the papers, whether Monica had used documents he could access, or whether an outside broker had copied his identity too. Before the representative left, I called a licensed investigator recommended by our company attorney. I hired her to document only lawful business and public activity connected to the application. She stated her limits plainly. She would not enter Jason's home, hotel room, car, or private office. She would not plant a device, pretend to offer criminal help, or manufacture a conversation. Under our state's rule, she could record words spoken audibly from a lawful seat in a public place where no reasonable privacy existed. She could also review public records and observe scheduled business meetings. If they move somewhere private, you stop, I said. I stop. My first instinct had been to call Jason and ask what he had done. Instead, I protected the company before I protected my feelings. I suspended his purchasing access, changed the approval path for every open order, and ring-fenced the payroll account so 32 families would not become collateral damage in a fight between a father and son. Then I called him. I need you at the office tomorrow morning. We are leaving for the honeymoon. A lender has a personal guarantee with my signature. The silence lasted long enough to become an answer, but not proof. Monica handled some wedding financing, he said. Maybe something got mixed with the business file. Did you apply for $275,000? I cannot do this while you are accusing me. I am asking. This is exactly why her family thinks you are difficult. He ended the call. The next morning, Jason did not come to the office. He sent the lender a new corporate resolution instead. It claimed the company directors had met 2 weeks earlier and approved the excavator purchase unanimously. Kowalski Mechanical had only one voting director. Me. No meeting had occurred. The false resolution also moved the requested funding date forward by 48 hours. That was Jason's countermove. He was no longer explaining a possible mix-up. Someone was trying to push money through before I closed the path. The lender kept the fraud hold in place. Its compliance officer asked me not to contact the supposed equipment seller while they preserved records. The invoice named Garden State Excavation Supply. It showed 1 excavator, 2 trench boxes, and a hydraulic breaker. Our field superintendent studied it for less than a minute. Those model numbers do not belong together, he said, and we have nowhere to store another excavator. The business address was a mailbox rented the week before the wedding. Public registration listed Monica as the contact for a similarly named event consulting company at the same address. That connection was suspicious, but it still did not establish that she or Jason created the invoice. Ray came to my office after work. My younger brother had spent 36 years running union crews. He placed his coffee on the same scarred table where Jason had learned to solder copper pipe at 12. You going to make this disappear? He asked. I stopped the money. That is not what I asked. Ray had watched me pay Jason's rent after he quit school. He had watched me replace the wrecked car without requiring Jason to take the bus for even 1 week. His mother would not want him in jail. I said, his mother would not want you lying to a lender either. I looked at the photograph on my desk. My wife was leaning against my first service van, wearing the gold watch. What if reporting him destroys his marriage? Ray shook his head. You still think money can choose which consequence reaches him. That hurt because it was true. The investigator verified the story Monica's parents had told me before the wedding. They did live in New York. They did not own the Manhattan property they claimed was being refinanced. They rented 1 floor. Public records showed a substantial tax lien tied to a failed consulting business, plus civil judgments from unpaid event and clothing accounts. Being in debt did not make them criminals. Lying about their status did not prove they knew about the forged loan. It answered only one question. They had allowed the man they mocked to pay for the wedding because there was no hidden family fortune coming later. Their social position was a set built with borrowed furniture. Jason called that night. Restore my purchasing access, he said. The company needs me. The company operated before you arrived this morning. Monica's father says you are panicking because you do not understand modern financing. Ask him whether he owns the Manhattan building. Jason went quiet. You investigated her parents? I verified the explanation used when I was asked to cover the wedding. You promised the money, and I paid every dollar I promised. This call is about a forged company loan. It is all the same money to you. There, it was the belief I had purchased one rescue at a time. No, I said. Payroll is not wedding money. Company credit is not your inheritance. My signature is not a family coupon. If you report this, you will embarrass all of us. Did you sign my name? He ended the call again. The lender then received a request for an in-person corrective signing at the hotel where Monica's parents were staying after the wedding. The request said I had misunderstood the electronic paperwork and would confirm it face-to-face. I had agreed to no such meeting. The hotel business lounge was open to the public. The investigator could lawfully sit there before the scheduled appointment, but not enter a guest room or reserved conference suite. I told her to proceed. I also told the lender in writing that I would not attend and that no one had authority to approve a draw for me. The money was safe. The truth was still moving. Before the hotel meeting, I asked our bookkeeper to separate every wedding payment from every company account. The result was simple. Exactly $85,000 had left my personal savings under signed vendor contracts. Not one wedding bill had been paid by Kowalski Mechanical. Not $1 had been paid to a building I owned. The venue was independent. The vendors had completed their work, and the gift was finished. The proposed loan was separate. Jason tried to blur those two facts in an email to our supervisors. He wrote that I had frozen a necessary expansion because I was angry about a wedding toast. He asked them to support his modernization plan. That message was his second pressure move. If the employees believed this was a wounded father punishing a son, they might defend Jason before seeing the forged papers. I gathered the supervisors around the break room table. The company has no approved excavator purchase, I said. No payroll money is missing. Jason's purchasing authority is suspended during an outside review. I will not ask anyone here to choose between us. The field superintendent looked at me. Did he steal? I do not yet have an official finding. Then why suspend him? Because access is not a verdict. It is something an owner protects while facts are checked. No speech made them comfortable. But the next morning, every crew received materials and every paycheck cleared. Protection had to be visible before justice could become believable. The investigator arrived 40 minutes before the scheduled signing. She bought coffee and took a public table near the business lounge entrance. A brass sign stated that the lounge was open to hotel guests and visitors. Conversations carried across polished stone and a fountain that had been switched off for maintenance. No lender representative came. The lender had never agreed to send one. Jason and Monica arrived with a leather folder and sat 6 feet from the investigator. They believed they were waiting for a signing officer. They did not know that the lender had already placed their request with compliance. The investigator did not speak to them. She recorded only what any guest in her seat could hear. Monica opened the folder. "The new resolution looks cleaner," she said. Jason answered, "It has to match the guarantee." "What if your father says he did not sign either one?" "He will say that until he sees what happens to the company if this becomes public." "That is not an answer." Jason lowered his voice. "I copied his signature onto the $275,000 guarantee. I made the excavator invoice. I know he never authorized it." The words were clear enough to survive without interpretation. Monica asked why he believed I would approve the draw after discovering the papers. "Because he always covers me," Jason said. "He will be angry. Then he will find a way to call it helping." That was the first part of the recording. The conversation continued for another minute. Near the end, Monica asked about an object from my house. Jason answered with an amount and a plan involving her parents. When the investigator later played that section for me, I stood up and walked out of the room. Our attorney asked me not to discuss the missing property outside the formal review until the recording had been preserved and presented unedited. I agreed. The investigator stayed at the hotel after Jason and Monica realized no signing officer was coming. She photographed only their departure through the public lobby, preserved the original audio, made a read-only working copy, recorded its digital fingerprint, and wrote down the public seating conditions. She did not follow them to their room. At my office, she played the first segment for our company attorney and me. I copied his signature. My son's voice sounded ordinary. That was the worst part. There was no panic, no threat, and no stranger forcing him. He spoke like a purchasing coordinator describing a late delivery. The attorney paused the audio. This supports the fraud hold. The lender will authenticate its own loan records. The recording does not replace their review, and it does not make an arrest automatic. What do I have to do? Sign a truthful affidavit stating you did not authorize the guarantee or resolution. You can explain Jason's access and your relationship. You cannot ask compliance to treat a felony-sized forgery as a clerical misunderstanding. I looked through the office glass at the people finishing the afternoon shift. Their health insurance, rent, and grocery money moved through a company account Jason had tried to place behind a false loan. Prepare the affidavit, I said. The attorney did not make that decision for me. Ray did not make it. The lender did not make it. I did. That evening, I went home and opened the cedar box. The gold watch was gone. The pale oval in the velvet told me the truth at once. Jason had known the safe combination since his mother was ill. We kept medical directives and insurance papers there in case I was unreachable. I had never revoked that trust after her death. On the empty velvet lay one short strand of gray hair caught beneath the hinge. My wife's hair had turned gray during chemotherapy. I sat on the floor with the open box in my lap until the room became dark. The watch was worth less than the wedding band's overtime charge. Its price was not the loss. The loss was that Jason had taken the one object I planned to hand him freely. When Ray arrived, he found me in the same place. Did the investigator say where it is? He asked. The complete recording may. Then call the police. Tomorrow. Ray sat beside me. That word has paid for a lot of Jason's mistakes. Tomorrow is the lender's fraud review. They want everyone present before they deny the draw and make referrals. And after, I closed the cedar box. After, I tell the truth, even if he calls me Dad. The next morning, I signed the affidavit. I stated that I had never approved the loan, corporate resolution, invoice, or equipment purchase. I described Jason's limited purchasing role and gave the lender permission to compare the application with our authentic company records. I also admitted facts that made me look foolish. I had paid Jason's rent more than once. I had covered the wrecked car. I had given him access to family records during his mother's illness and never reviewed that access later. I had ignored his belief that my money would always turn consequence into a misunderstanding. Tough love becomes a pleasant phrase when a parent uses it only after the child has done something unforgivable. For years, I had called my behavior sacrifice. Some of it was love. Some of it was fear that Jason would stop needing me. And some of it had taught him that another person would pay before a consequence reached his door. The fraud review conference took place in a lender office, not at the wedding hall. The compliance officer attended with lender counsel. Jason and Monica came because they had demanded a chance to prove that I authorized the financing. I asked Ray to attend as a family witness. He had no company vote and no claim to my money. He knew Jason before wealth, marriage, or status became part of the argument. Before we entered, the compliance officer explained the meeting's limit. We can deny funding, preserve records, close related applications, and refer suspected crimes. We cannot decide guilt or sentence anyone. If you provide the recording, it will be reviewed for authenticity and lawfulness. Understood, I said. Mr. Kowalski, if the evidence identifies your son, do you still want it included? Through the glass door, I saw Jason straighten Monica's coat collar at 5. He had waited beside my service van for me to come home. At 12, he could solder a joint smoother than men twice his age. At 17, he held my hand at his mother's funeral because I could not stop it from shaking. Include it, I said. Jason entered carrying the same leather folder from the hotel. Dad, let us fix this without strangers. The strangers are here because my name is on a loan application. Monica sat beside him. The wedding has made everyone emotional, she said. My parents can repay part of the cost when their building refinance closes. The compliance officer opened a file. This meeting concerns $275,000 in proposed equipment financing. It does not concern reimbursement for a wedding. Jason slid the false resolution across the table. My father approved expansion verbally. I prepared the paperwork to save time. Did he authorize you to copy his signature? Lender counsel asked. I did not copy anything. Did you create Garden State Excavation Supply? It is a legitimate broker. Why does it share a mailbox with Mrs. Kowalski's event company? Monica crossed her arms. Hundreds of businesses use mail services. The compliance officer placed my authentic company rules beside the false resolution. Our real policy allowed Jason to approve ordinary purchases up to $25,000 within an existing job budget. Any borrowing required my written approval and direct verification by the lender. Did your father give you direct borrowing authority? She asked. He gave me responsibility for expansion, Jason said. That is not the question. Jason looked at me. You have treated me like a helper since I joined the company. You were purchasing coordinator. That was real work with real limits. Monica leaned forward. Frank is angry because my father made one harmless joke at the wedding. I took the wedding ledger from my folder. Here is every payment. Exactly $85,000 from my personal savings to an independent venue and independent vendors. The contracts were completed. I have demanded no refund. Lender counsel reviewed the first page. None of these payments came from Kowalski Mechanical? None. Do you own any portion of Hudson Glass House? No, my company repaired its boilers once. A plumber does not own every building whose pipes he keeps from freezing. Ray almost smiled. Jason did not. You could afford both, he said, the wedding and the loan. Affordability is not authorization. You built the company for me. I built it with people who arrived before sunrise and expected their signatures to mean something. The compliance officer asked whether Jason had ever served as a director. No. Did he attend the meeting described in this resolution? There was no meeting. Monica said, This is a family succession dispute, not fraud. Then the evidence should show that, I answered. Ray said nothing. His work-ruined thumb moved slowly along the rim of his coffee cup. I placed the cedar box on the table. Jason's face changed. Where is your mother's watch? I asked. Why are you asking me? Because you knew the combination. That safe was open to family. Ray could have taken it. My brother's thumb stopped moving. Monica touched Jason's arm. Do not let him turn grief into evidence. The compliance officer asked whether the watch related to the proposed loan. The preserved recording will answer that, I said. Jason looked toward the door. Lender counsel told him he was free to leave, but the loan review and any referral would continue. He stayed. He still believed I would stop before the consequence became real. I placed the investigator's authenticated working copy into the conference system. Jason was present. Monica was present. Ray and 2 independent lender witnesses were watching them. I pressed play. The first voices were the ones we had already heard from the hotel lounge. Monica said, "The new resolution looks cleaner." Jason answered, "It has to match the guarantee." Then came the admission he had denied at the table. I copied his signature onto the $275,000 guarantee. I made the excavator invoice. I know he never authorized it. The compliance officer looked from Jason to the signature page. Ray's jaw tightened, but he remained silent. The recording continued beyond the section I had quoted in my affidavit. Monica asked, "What if Frank refuses the draw? He will fold. He paid $85,000 after your father called him, hired help. You said that money was gone." "It is. The designer deposit put us $18,000 over. And your mother's watch," Jason exhaled. "I pawned it for the $18,000 deposit. The ticket is in my desk." Ray pushed his chair back an inch. "On the recording," Monica said, "your father planned to give you that watch. Then I was going to get it eventually. How do we get it back? Once the loan lands, we buy it back, clear your parents' tax debt, and tell Dad the money went into equipment. He has covered me my whole life. He will not send his only son to jail." That was the new fact the room had not heard before. The loan was not for an excavator. The false invoice would turn company credit into money for a pawned family keepsake, wedding excess, and a debt belonging to people who had pretended they needed nothing from a plumber. The recording ended. Monica's face had lost all color. Ray opened the cedar box. He stared at the empty velvet and closed it again without speaking. The compliance officer asked Jason whether the voice was his. Jason looked at me. "Dad, I can explain this at home." "Answer her." His lawyer was not present because he had chosen to attend a commercial review as an applicant. Lender counsel reminded him that he could stop speaking and seek advice. Jason stopped speaking. His silence was not treated as a confession. The recording, loan file, false invoice, public mailbox record, and my sworn denial stood on their own and would receive separate review. Monica said the lounge conversation had been private. The investigator's report had already addressed that challenge. She had occupied a lawful public seat, recorded only audible speech under state law, and entered no room or private space. Lender counsel did not declare the issue settled for every future court. He preserved the objection with the evidence. Then the compliance officer made the first formal decision. The lender denied the $275,000 draw, closed the application for suspected fraud, barred any funding under the disputed resolution, and placed a preservation hold on every related electronic record. She signed the decision while we sat there. "This protects the lender and Kowalski Mechanical," she said. "It is not a criminal conviction." "What happens next?" Ray asked. "We refer the package to financial crimes. Mr. Kowalski must decide whether he will provide a victim statement concerning his signature and watch. I already had the decision in my hand. I will." Jason leaned across the table. "You would put your own son in jail over a loan that never funded." "No," I said. "Your choices may put you there. I will not lie to keep them from reaching you." That afternoon, a county detective accepted my report. I gave him the cedar box, the authentic signature samples, and the investigator's preserved recording information. He told me an accepted report was the beginning of an investigation, not permission to announce guilt. Jason and Monica left the lender office together. No officer waited behind the door. The investigation took 5 weeks. Legal process connected the false supplier mailbox and deposit account to Jason and Monica. The lender's file showed that Jason uploaded the copied guarantee from his company login. A licensed pawnbroker produced the ticket and surveillance record for the gold watch. The $18,000 had gone directly to the designer, who supplied wedding upgrades outside my capped budget. Bank records also showed a planned transfer to satisfy part of Monica's parents' existing tax debt. Investigators found no proof that her parents knew the money would come from a forged business loan. They were not charged merely for being vain, indebted, or dishonest about owning a building. Jason and Monica were arrested after warrants issued. Prosecutors charged Jason with forgery, attempted theft, business record fraud, and theft of the watch. Monica faced charges tied to the false supplier and attempted diversion. Those were allegations until resolved. I did not pay their bail, retain their lawyers, or ask employees to describe Jason as authorized when he was not. I did pay every worker and every valid company invoice on time. Before the plea hearing, Jason's attorney asked whether I would call the forged signature a misunderstood family authorization. He did not ask me to invent evidence. He asked whether my view had softened. My view of my son is complicated, I said. My answer about the signature is not. I also told the prosecutor I was not asking for the harshest available sentence. Protecting Jason from truth and demanding extra pain were opposite forms of the same mistake. Both would make his case about my emotions instead of his conduct. Months later, both cases ended through negotiated pleas. Jason admitted forgery and theft. Monica admitted her role in the attempted diversion. The court ordered restitution and imposed separate sentences based on their conduct. Jason's judgment included a custodial term. The exact length belonged to the written judgment. I never used it as a trophy. The wedding money did not return. I had promised $85,000. Vendors had performed, and I had paid them. Tough love did not reverse my own poor financial boundary. It meant I stopped using new money to erase the result. Monica's parents eventually left the Manhattan rental they had called their family property. Their tax lien and civil judgments remained theirs. I did not buy the debt, contact their landlord, or arrange their humiliation. Without my money and the false loan, the image simply had no fuel. At Kowalski Mechanical, Jason's employment ended under the same documented policy that applied to anyone who used company records for personal fraud. His name remained my son's. It no longer appeared on the purchasing authorization list. The police recovered the gold watch from the pawnbroker before it could be resold. It came back in an evidence envelope with a scratch across the crystal. I did not repair it immediately. For several semaines, I kept it in the cedar box exactly as it returned. The scratch reminded me that recovery was not the same as reversal. I visited Jason once after sentencing. He wore county-issued clothes and sat across a table, bolted to the floor. "Monica says this is your fault," he said. "What do you say? You could have signed the loan after the fact. That would have made the lie mine. You paid $85,000 for one night. Why was another $275 different? Because generosity is chosen. Theft decides for someone else." He looked toward the visiting room clock. "Do you still love me?" "Yes." "Then help me get out. I will write. I will answer honest questions. I will not purchase an escape from a judgment you earned." He stood when the officer called his name. For the first time in his life, my love and his rescue were not the same thing. 3 months later, Jason sent me a letter. He had joined a maintenance training crew. The instructor had handed him a length of copper pipe and rejected his first joint because solder had pooled on one side. Jason wrote, "He made me cut it out and do it again. He did not care who my father was. There was no apology in the letter, but there was one sentence that did not blame me. I wrote back, "Do it again until it holds." I did not promise him a job when he came home. If that day arrived, access would be earned under rules made with managers and councils, not granted during an emotional visit. On the anniversary of his mother's death, I took the gold watch to a repair shop. The watchmaker replaced the crystal, but left a faint mark at the edge because removing it would thin the case. That evening, Ray and I sat at the break room table after the crews went home. I placed the watch beside my wife's photograph. The second hand moved across the new glass, past the small remaining scar, and kept going. I had spent years believing a good father prevented his child from feeling every hard consequence. The watch taught me something different. Repair does not mean pretending the damage never happened. Sometimes love is the hand that helps. Sometimes it is the hand that finally lets go of the bill.